channel on the second and fourth Thursday of every month. The introductory program will be aired on Thursday, April 18. The guest is Anthony Laronde, and he will discuss freedom of expression. Tune in this Thursday at 8 p.m. for the Ministry of National Security and Legal Affairs and you. Know your rights. Know the law. Know your ministry. Know your procedures. A 90 minutes program on National Broadcaster, DBS Radio.
Welcome to a very special program this evening. Of course, as you may have heard, that we shall be launching the program starting tonight. The Ministry of National Security and Legal Affairs, and of course, in keeping with our mandate to ensure that we maintain a just and safe society, ensuring that everyone has equal access to the law and, of course, equally protected under the rule of law. So we shall be going forward hosting a series of programs with the main focus on actually giving the populace an idea as to what it is the Ministry of National Security and Legal Affairs is all about. What is the relationship, therefore, between the ministry and yourself, of course, in keeping with the mandate of your government to ensure that Dominica is maintained as a free and peaceful country for the enjoyment of all. And tonight we have with us the most distinguished, Anthony Laronde. I will leave it up to him to actually introduce himself. And as I said before, that the Ministry of National Security and Legal Affairs is working towards attaining a just, efficient, and respected justice system. And let me just emphasize that does not mean only that everyone should have equal access to justice and equal protection under the law. it definitely encompasses much more than that. Knowing your rights, your responsibilities, and obligation under the law is very also important. So tonight we'll be looking at a subject matter that has over the years and continues, of course, to generate tremendous public discourse and the protection of freedom of expression. But more importantly tonight, we will dwell on the whole issue of someone's protection to assembly and to associate under the Constitution. So let us tonight introduce Mr. Laron. And Mr. Laron, good evening to our wonderful listeners, those of you who are listening in Dominica and further afield. Good evening, Mr. Anthony Laron. Should I call you?
Good evening.
Your Excellency.
Yeah, thank you very much. Good evening, everybody. I am quite happy to be here and to contribute to the discourse in terms of making the law understood by everyone, making people feel at home with the law, making people know what the law is, because all of us and every country has to be governed by laws. As you know, Dominica is a democratic country governed by the rule of law, and as such we have the separation of powers, we have the judicial branch, the administrative branch, and the legislative branches of government. Now, the Constitution is our fundamental law, and I'll be looking at constitutional provisions to try to explain what they say and what your rights are. But before I go there, I think it is just proper that I should tell you a little background about me, because everyone might not know me, although I think most people know that I'm from Granby La Plaine. I think a lot of people in Dominica know as a former Attorney General. But I've been very fortunate in the field of law in terms of I've been a parliamentary counsel, chief parliamentary counsel, director of public prosecution, state attorney, and I've worked regionally quite a bit, acted in the office of Attorney General on numerous occasions in Anguilla, was chief parliamentary draftsman there, worked with CARICOM as the director of the CARICOM Legislative Drafting Facility. I had 6 attorneys working with me. And what I did there was to ensure that the laws of all CARICOM member states except Haiti and Suriname are compatible with the single market and economy of CARICOM. We were successful in terms of the single market. As you know, the single market is a reality in CARICOM. The single economy is not, because we have about 7 different central banks in CARICOM. I've been a consultant in the Caribbean, worked in international firms, and had an attachment with the CFTC, Commonwealth Fund for Technical Cooperation in St. Lucia. So essentially that is who I am in terms of my legal experience, and this is why I think I can contribute a little bit in terms of what the law is as we look at and we discuss protection of freedom of expression.
Thank you very much for your wonderful introduction here tonight. A very interesting resume, certainly, that you have, and you still look endlessly young. And when I came in tonight, I thought I was looking at this 17-year-old, the way you need to dress. So, good evening to you, again, to our wonderful listeners. Now, I want us to just to place emphasis on, I'll just allow you, maybe under the relevant section of the Constitution, to dwell a little on the protection of freedom of expression. But I would like us to actually place some more emphasis on the whole issue of one's protection of the right to movement. And I think that is something that I think has generated tremendous disgust for a while now. So I will allow you to actually look at the relevant sections. I think section 10 that it is.
Thank you very much.
Under the Constitution that deals with the whole issue of protection of expression.
Okay, as I said earlier, the Constitution is the fundamental law of Dominica. Every law, any law that is inconsistent with the provision is null and void. So every law has to be in sync with the Constitution. Now, let us go to the Constitution. We don't just talk about the Constitution and pretend that we know a lot and just talk about Constitution and say I'm a constitutional expert. I mean, that's not the proper way. We have to look at the document. So in front of me, I have the document. And we'll be looking essentially, because they're intertwined, at section 10 and section 11. Section 10 speaks to protection of freedom of expression. Section 11, protection of freedom of assembly and association. Very much intertwined. So let us look at section 10(1), that's subsection 1. It says, except with his own consent, a person shall not be hindered in the enjoyment of his freedom of expression. Essentially, a person is free to express himself or herself. And that includes the freedom to hold opinions without interference, freedom to receive ideas and information without interference, freedom to communicate ideas and information with interference, and freedom from interference with his correspondence. So he's free to communicate. However, most important is subsection 2, because it tells us nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this section, to the extent that the law in question makes provision for. I will stop there. Essentially, section 2 is telling us that the lawmaking power, the legislature, parliament, can pass a law which is not inconsistent or in contravention of your fundamental right to freedom of expression, where the law in question makes provision that is reasonably required in the interest of defense. Simply, that if the law is required in the interest of defense, it can impinge on your rights under subsection 1. And the same thing holds for public safety, for public order, for public morality, or public health. So I'm going back.
I'm sorry. You said subsection 1, or did you mean subsection 2?
Subsection 2. That's what I'm reading from now. Yeah.
Thank you.
But I'm saying, but subsection 2 speaks to the freedoms that's entrenched in subsection 1. And subsection 2 is saying that a law can be passed that impinges, that takes a little bit of your rights, that muzzles your rights to a certain extent, which you have under subsection 1. But it tells you that can only be done, that law has to be reasonably required in the interest of defense, public safety, public order, public morality, or public health. B, it is reasonably required for the purpose of protecting the reputations, rights, and freedoms of other persons, or the private lives of persons concerned in legal proceedings, preventing the disclosure of information received in confidence, maintaining the authority and independence of the courts, or regulating the technical administration or technical operation of telephony, that is communications. So once again, that fundamental right which you have in 1, which that without your consent you cannot be hindered in the enjoyment of your freedom of expression, that can be curtailed if it is reasonably required for these 2 exceptions are spoken about. And it goes further. It says if that restriction that imposes restrictions upon public officers, that again reasonably required for the proper performance of their functions. So the most important word here is reasonable. Is the law reasonable? And if it is reasonable, a court will not strike it down because it is necessary, for example, under subsection A, for public safety, for public order, for defense. Because if you have a democratic country, you have a country governed by the rule of law, it is necessary that Parliament, from time to time, will have to pass legislation that takes away from your fundamental rights in the public interest. And it goes further, it says, and except so far as that provision, or as the case may be, the thing done under the authority of that law is shown not to be reasonable, justifiable in a democratic society. So it is saying, and if that law has to be, I'm putting it in the positive, it has to be reasonably justifiable in a democratic society. So any law, the government can pass any law once that law is reasonably justifiable in a democratic society in the interest of public safety, defense, public order, public morality, or public health.
So in a nutshell, just for greater clarity for those who are listening, that right, even if it is protected, but it is not absolute.
That's correct. You see, that's not a law that you can, that law is not absolute in terms of the common good is bigger than your individual good. We live in society, and society being what it is, all of us have to enjoy our rights. So your right you can't enjoy your right to the extent that it impinges on my right or impinges on the public good of society. So essentially, this is what it's saying. All of us have these fundamental rights, but those rights, the government in the public interest, the government in terms of public order, defense, public safety, the government can pass a law that will curtail those rights.
Okay. I wanted to give a little more currency to the whole issue of public interest.
Mm-hmm.
And maybe you can give some examples as to what actually constitutes public interest.
Public
interest.
Public interest.
Yeah.
Okay. In terms of public interest, you might have public disorder. You might have a situation where, unless legislation is passed, for example, good example, state of emergency, the power to have a state of emergency. In terms of the government, the police advises the government and says, we need to curtail people's freedom of movement. We need to have a state of emergency. We need people to be at home from 5 o'clock in the afternoon till 7 next morning. We need no political meetings for X period. Because if you have political meetings, if you have people out on the road at a certain time between 5 to 10 next day or whatever the time is, it is possible that it will create problems in the society. It is not in the public interest. And the moment that is the situation, government can pass legislation and say, have a state of emergency and say, we need to curtail rights. We cannot have people on the road. After a hurricane, people have to get home by 5 o'clock because we need to safeguard the business people. We need to safeguard private property.
And we are still dwelling on the whole issue of protection of freedom of expression. And you actually give the examples of the legal facility that enables Parliament to pass laws for the precise reasons that you draw some reference under A to C, subsection 2. Now, we made reference to public morality. Mm-hmm. What do we mean by that?
Okay, you can have a situation where people are spreading images of children, images of homosexual activity, images that is not acceptable in a Christian democratic country, which Dominica is. And the government might very well say, we need to pass legislation to stop that. Or we need to stop this big activity that is going to take part, that is going to happen at Balapak. We need to stop it because what this foreign artist is coming to do is inconsistent with our fundamental beliefs. So in terms of public morality, government said, no, we need to step in. Public health, we also need to step in because what is going to happen if we allow that particular activity to happen is that it will impinge on our society and we want to be good for society. Interests of defense, we need to move in because if we do not do that, our defense will be compromised. So we need to close certain ports at a certain time because otherwise our defense will be compromised.
Okay, we are speaking to the most distinguished, as you heard just now, the former Attorney General and legal consultant in the area of drafting, legal drafting, Mr. Anthony Laron. And we shall be opening up the line just now. You can call 448-3284, and or you can also call 1-800-327. And we are here with you until 9:30. We shall take a break and be back in a while.
The Ministry of National Security and Legal Affairs presents Legal Affairs and You. Know your rights, know the law, know your ministry, know your procedures. Tune in to DBS Radio and view on the DBS Facebook page and on the YouTube channel on the second and fourth Thursday of every month. The introductory program will be aired on Thursday, April 18. The guest is Anthony Laronde, and he will discuss freedom of expression. Tune in this Thursday at 8 p.m. for the Ministry of National Security and Legal Affairs and You. Know your rights, know the law, know your ministry, know your procedures. A 90 minutes program on National Broadcaster, DBS Radio. The Ministry of National Security and Legal Affairs presents Legal Affairs and You. Know your rights, know the law, know your ministry, know your procedures. Tune in to DBS Radio and view on the DBS Facebook page and on the YouTube channel on the second and fourth Thursday of every month. The introductory program will be aired on Thursday, April 18. The guest is Anthony Laronde, and he will discuss freedom of expression. Tune in this Thursday at 8 p.m. for the Ministry of National Security and Legal Affairs and You. Know your rights, know the law, know your ministry, know your procedures. A 90 minutes program on National Broadcaster, DBS Radio.
We are back live with our program here tonight, and Mr. Laron, maybe we could actually go to section 11 of the Constitution as we look at another important subject area, and something, of course, an issue that has actually caused tremendous discuss within the public domain over the years and up to this present moment. And there seems to be some element of misconception as to whether someone has absolute right of freedom of assembly and association. And so I want us to just for a while just give some currency to that section and expound on it a little more for the understanding and edification of the general public.
Thank you. Well, I think we'll all agree that the protection of freedom of expression is very close to the protection of freedom of assembly and association. So let us look at Section 11 of the Constitution. It starts the same way that Section 10 started, which says, except with his own consent. And it goes on to say, a person shall not be hindered in the enjoyment of his freedom of assembly and association. That is to say, his right to assembly freely and associate with other persons, and in particular, to form or belong to trade unions or other associations for the protection of his interests. So one has enshrined in the Constitution the right to assembly and to associate. And that's very important in a democratic society. However, just as is said in Section 10, in Section 11 it says, nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this section to the extent that the law in question makes provision that is reasonably, that word is coming back again, reasonably required in the interest of defense, public safety, public order, public morality, or public health. So, the same way that your freedom of expression can be curtailed, the same way your freedom of assembly and association can be curtailed by a law that is reasonably required in the interest of defense, public safety, public order, public morality, or public health. By a law that is reasonably required for the purpose of protecting the rights or freedoms of other persons, or by a law that imposes restrictions upon public officers that are reasonably required for the proper performance of their functions. Except, and the last provision, Section 10, says the same thing, except so far as that provision, or as the case may be, the thing done under authority thereof is shown not to be reasonably justifiable in a democratic society. So once the law is reasonably justifiable, the law will stand. The only way the law will fail, that a court will hold the law to be unconstitutional, is if the law is not reasonably justifiable. When you look at the circumstances that cause government to pass X law, the question is, passing that particular law, was it reasonably required? And if it was reasonably required in the interest of defense, public order, public safety, health, public morality, that's the law, and no court will strike down that law.
Yes, absolutely. Just to give some examples where the government can be justified in passing a law that is consistent with one of the measures contained therein, that is to say, under subsection 2, A, B, and C. Maybe we want to use a practical example or examples before we move to a next piece of legislation that we have to discuss here tonight, namely the Public Order Act. You can recall that we still have the lingering impact or effects of COVID-19. maybe we could use COVID-19 as a practical example when the government had to do certain things in interest of public health. I'm not sure if you want to.
That's excellent.
Yes.
I mean, excellent. In terms of, that's a good example. You have COVID, so you pass legislation, and you say that people have to stay home. That people cannot be out. That you could have said people have to wear masks. You could have said that people have no choice but to go to X place, X hospital, once they're positive.
So,
And I'll go a little direction that I think that you probably could have passed a law and say people have to take the vaccine. And I says, that is my opinion, but I'm saying in the interest of public health, if X amount of people, if the health authorities say to you that it is necessary for the public good that everybody has to take the vaccine, and the government passed that law, I think the court will probably say yes, justifiable. Because you're looking at the common good. The bottom line is always the common good. You see, I have a right, but that right is subservient to the right of everybody else.
I think that's an excellent intervention you made just now on the whole issue of, which of course may be construed as bordering on something controversial when you referenced just now the whole issue of
that's why I said that is just
mandating that everyone should take the vaccine. You said that's your opinion. But having read the law, having read the parent law of the land, and is that really an opinion, or would it be justified?
And that's a test. Would it be justified? That's why I says, if the public health authority says, in the interest of the public, we cannot have 1/3 of the population not vaccinated. The government might well say, well, in the interest, we do not want everybody to die. And that is what the health experts are saying. And I'm saying, if in that case you pass that law, I'm not saying the law would have been a good law in terms of the end result, but I'm saying a court would say justifiable. That's the test. Is it justifiable in a democratic society?
Yeah. So, during the COVID, there was certain restriction in terms of movements of and if you had infection in a particular community during the actual initial stages of the COVID-19 virus, there are certain steps were taken. A number of people, of course, within the legal fraternity, had their own interpretation. So you're saying, based on what you know, what you have read, based on your opinion, that the government was justified in doing so.
Yes, government would have been justified, in my opinion, you see, because you have a health crisis. It was a health crisis. And what do you do? For example, government of Anguilla says, no one can leave Anguilla after X date. If you leave, you cannot come back in. And that applied to nationals and non-nationals. After that, they says non-nationals can leave. But you have to get permission. It has to be you must have a reason. Because we do not want you leaving and coming back and putting everybody at risk. And in retrospect, it made a lot of sense. Number of cases 3, number of cases 6. Because they locked down, essentially, they locked down everybody in the country. Harsh decision to make, but it was reasonably justifiable. So the same thing happens in terms of even defense. I mean, in the interest of defense, you might say that no pleasure boats can go out. Only army boats, only RSS boats and police boats can go in your territorial waters. And if you say so, and it's justifiable in the interest of defense, you right on board and the constitutional benefit can be taken away.
Yeah. Okay. Excellent. So, again, it's 20 minutes to 9 o'clock, and this program shall end at 9:30. We are discussing